you don't have an estate plan, that's not gonna happen. So it's key and critical to have an estate plan. You know, death is not something people really wanna talk about, but it is necessary to discuss and prepare for your finality, so that you don't leave burdens behind for your loved ones. A lot of people are misinformed regarding what becomes of their estate, their life's completion. So some of the results of this is anxiety, unnecessary anxiety, family disputes and legal battles over your assets. So why do most people fail to take care of something that's very important? Some people say, well, I don't want to think about dying. I'm too young to die. Oh, I just haven't done it yet. But procrastination is not very good. Procrastination leads to unproductivity and it leads to wrong decisions. So it's very important not to procrastinate, but to take the time, make the time, set goals and timelines in terms of this estate plan. Because procrastination can be financially devastating. Estate planning is vital for everyone, regardless of your net worth, your income, your family circumstances. And without a proper plan for the future, then you're leaving your children and other loved ones with complications, things that could be avoided if you had an estate plan in place. As a matter of fact, over 70% of Americans completed their lives without any form of an estate plan. And millions of people died because of COVID-19, hypertension, and diabetes. So it's very essential to have an estate plan in place. And an estate plan is more than just having a living trust or a will. You need to have a power of attorney, advanced healthcare directive. You also need to have retirement tools in place. We have some people here, Shante and TK, that can help you with that. So what is estate planning? Estate planning ensures that your final property and your health care wishes are honored, and that your loved ones are provided for in your absence. And it consists of, like I said previously, a living trust or will. In this case, a living trust is better than a will, and I'll get into that a little later. With a living trust, power of attorney, advanced healthcare directive, and also with what I call the HIPAA authorization. I'm going to get into what that is later on in the presentation. So an estate plan is designed to help you to achieve three major goals: to transfer your estate to the loved ones of your choice upon your demise without the expense and delay of probate, protect you from a guardianship if you become disabled, ensure that your health care desires are achieved if you become physically or mentally challenged. So what is an estate? An estate is all the assets that you have, whether it's real estate, stocks and bonds, life insurance policies, bank accounts, personal property, automobiles, jewelry. So there's a great need for estate planning because it can eliminate and reduce problems such as financial burdens, which can be in the form of probate fees, which are paid to the executive estate and the attorney who assists with the probate process. Probate is a court proceeding to validate a will. It can be very costly and a very long process. It can take years. I know someone who's still in the probate process now. It's been 3 years. And the beneficiary has not received their assets at all. So you have to be mindful of that. Another financial burden is death taxes. Estate assets are improperly arranged due to liquidity. There's not enough liquid cash assets to pay for estate settlement costs. There may be a lack of cash flow to take care of your loved ones. But all this can be avoided if you have an estate plan in place. Transfer assets. Assets may be subject to probate delays and expenses if you go the route of the probate process with the will. You can avoid all of that. You can avoid all of that with the living trust, because the living trust does not have to go through the probate process. Care of minors. Parents can nominate a guardian for their minor children in a living trust. And if the parent doesn't nominate a guardian, the court will appoint a guardian. You have to be someone that's going to be taking care of your children in the best interest of your children. So you want to make sure that you name a guardian in the living trust yourself, someone who you know personally and So how can estate plan help you? An estate plan can help you identify the family members and other loved ones that you wish to receive your property after your death. Ensure that your property will be transferred to those you have identified as quickly as possible. You can help minimize the amount of taxes that will need to be paid in order for your property to pass to your loved ones. And it can avoid the time and cost associated with the probate process. And I kind of touched on that. You can avoid they can dictate the kinds of life prolonging medical care you wish to receive should you be unable to make those decisions yourself. How many of you have heard of payable on death bank accounts? Okay. Okay, good. Because that's a good thing, because you can name of your bank accounts, whether it's a checking or savings account, you can name the beneficiary of your money in your accounts. Good. That's a quick way of getting.
Is that the same as adding on as a second,
account holder? No.
Account holder.
No, it's not. You have to actually complete a form that the bank will give you. You say it's payable on death, and you name that person as your beneficiary. Could be your daughter, could be your son, grandson, whoever you name.
I used to do that in banking, so it's totally separate. It's a bank account just for that.
With the person whose name is on the account, doesn't the money automatic?
No.
No.
I mean, your spouse is on the account?
They just have access, but that doesn't necessarily mean they're the beneficiary of the assets.
Let's say you got a joint account, husband and wife.
Yeah, that's-
And let's say the husband kicked the bike.
Yeah.
I mean, the wife never said, oh, let's say you got a couple of $8,000 to $10,000 in the account. Wife can still take money out of the account, although you receive, right? You got a joint account.
It's still an account holder. Now, in a joint account, that's different, but what she's talking about is something a little bit different. Yeah.
Yes.
not
Yes.
your spouse, but about your children?
Oh, yeah.
Yes.
Okay.
Oh, okay.
Not joint.
Yes.
Right.
Yes.
Yeah. Okay.
Oh, okay, that's okay.
Yeah.
As long as spouse is spouse.
Okay, so that doesn't apply to your child? That doesn't apply to your child? If you have one of your children as a second account holder, that doesn't apply to them? They don't have access to that account?
They have access, but you have to actually go through this particular aspect called payable on debt. It's a form that the bank will give you. You specifically name, Joe Blow will be my beneficiary.
But it's,
And then when you pass away, you have to submit a death
Yeah,
certificate to the bank
Yep.
representative, okay, and administration papers.
Mhm.
Because then you're not gonna be able to get that money out of the account.
Right.
Yes.
Even if they are second?
It's not about it, If you don't name
You have to have
Yeah.
directives.
beneficiary.
And when I was at banking, we had to send it to our legal team, and they had to verify the documents are accurate before we
Is it-
could
yeah, they
release
don't
fines
want-
or release anything to the
They don't want
family.
your family members to try to steal your money. So it has to be named. Otherwise, anybody in your family.
But if you,
But your name is already on
on
there.
there, how's they still? If I had my child as a account holder on my account, she should have access to that money, no?
She has access to it, but like she was saying, you have to, like I'm saying.
So
have
you
to
got
complete-
decency in order.
Right, exactly, because there's a lot of fraud, there's a lot of potential fraud involved with this.
Exactly.
So the bank has to protect themselves
but
from
it's
suits,
not.
litigation.
Yes.
So that's why they require this.
Yeah, it's the fraud, or maybe they're doing something they shouldn't be doing. Like if you had a lot of money in your bank account and they just take all of it out the day that you're deceased, it's not good.
And remember, your debtors, like when she was just talking about probate, your debtors still have access. So remember, when you die, your debt doesn't go away. So the whole
Exactly.
probate situation is still a real thing, regardless if the account is joined or not. So if it's not protected by the trust and it doesn't have directives, it can still go to probate.
Exactly,
That's
right.
good, right? So,
Probate,
but
yeah.
it's not good to put minors as a beneficiary. The minors, you know, like someone, I'll say you like put kids 9 to 10, 12 years old as beneficiaries, that ain't good, no minors. So that means whoever their guardian is, will get access to that money too, right? Yep. Yeah.
Okay.
I do have easy man.
Yes.
No, we can go ahead. No, I was- Do you have a hard copy of this that we can like reference when the class is?
No,
is
but I do
over,
have this.
or you have
This- I have a book that you can purchase.
Oh, okay.
And I go into greater detail in the book about living trust, charitable
Yeah,
trust.
excellent.
It's a great book.
Thank you.
How much is it going?
It's $20.
Yes. Yes, we use that book for all our clients. Excellent book, because it breaks it down.
Okay.
Okay, after my presentation.
You have a question,
Yes,
Tiffany?
ma'am. So I'm just making sure I understand. So even if you have a joint account, because of the steps, you advise that we still do go through the payable of debt?
Yes, absolutely, yes.
Okay, so go to the bank and ask about that form?
Yes.
Ask about that form and get that done?
That's right.
Okay, thank you.
Uh-huh.
Is it fee for this? No.
Okay, so what is a will? A will is a written document signed and spells out how you want your assets to be distributed, who to whom and when. But it's only effective when you die, whereas a living trust is effective during your lifetime. You can make changes to the living trust for your benefit and the benefits of your beneficiaries. Now, the executive of a will is responsible for managing the affairs of the estate as it progresses through the appropriate process. And the court will oversee your estate, payment for your outstanding obligations, and distribution of your assets according to the terms of your will. But the executive has to hire an attorney to help them go through the appropriate process. They can't do it themselves. It's too complex, and it's very legalistic, so they're not gonna understand by themselves. They need an attorney. So this is why it can be very costly and expensive and long. So you can avoid all that with the living trust. Okay, yes, sir.
Did you say, so you got a will where you have to go to probate or you will die? If a person dies and they left a will,
You have to go through the appropriate process.
yeah, cause I know a client that died, had a will set up for their 3 kids, but one of the kids wanted contested will. So it's tied up, the contested will, so it's tied up right now, it's tied up for like 3 years.
Yeah.
So a will can be contested, right?
Mhm.
But the trust can't be.
Right.
So living trust is a document that details again how you want your estate handled and everything else. And it consists of how you want your assets distributed and passed on. And there are 3 parties to a living trust. You have the settlor, the creator of the trust. You have the trustee, the person that manages the trust, and the beneficiaries, the people who of course are gonna get the assets, your assets upon your passing. So setting up a living trust is one of the most important things you can do for yourself and for your family. Because you can transfer your assets quickly with the living trust as opposed to a will, because it doesn't have to go through the appropriate processes. It's a private document, it doesn't have to be recorded. Like a will does, a will has to be recorded, so everyone's gonna know your assets. Your asset portfolio, you don't want that, right?
You mean like your creditors?
Your assets, whether it's house, your property, stocks, bonds, whatever your assets may be, because that's gonna be dictated, spelled out in your will.
But isn't it spelled out in the living trust also?
Yeah, but the living trust doesn't have to be recorded, so no
So
one's
it's
gonna.
different than like, yeah.
So it passes the public view.
So it's respected upon your death.
What did you say?
If somebody passes, they respect the living will, or the living trust that is, so they'll be, basically can't be contested.
A living trust may be contested, but the thing is it doesn't have to go through the appropriate process. The key is with the living trust is to make sure that the person who signed it is of sound mind. If a person contests a living trust, they have to prove that the person that made it, settled it, was not of sound mind when they did it.
Okay.
So how they gonna prove that? You see what I'm saying?
What if they got documentation from the doctor and all that stuff?
Okay, well, see, the thing is, well,
And they've got to contest it. Let's say they go, let's say the son and daughter, the kids, the one the kids want to contest it, and they say, okay, let me go to mama's doctors and get the medical record showing that she was on this medication, that medication, she was getting there a little dementia, and they want to contest it because they might leave one kid more than the other one, so they want to contest it. Because you said a key thing. It won't go through probate, right?
No.
But they still can contest it.
okay, it's still possible it could be contested, but again, see, you have to look at all the facts around that, because at the time when she made the living trust, she may not have been taking those medications, she may not have had dementia.
So it all depends on the date that they were put
Yeah,
together.
so it's a lot of different
Okay.
factors that you have to.
Can you repeat that again, Carmen? I didn't hear you. Can you repeat about
have been taking those medications at the time she made the will, the living trust. So if she wasn't taking those medications that were affecting her mentally at the time she made the living trust, they're not gonna be able to contest the living trust. You see what I'm saying? So there are a lot of different factors that have to be reviewed and analyzed. See? But chances are, most living trusts cannot, chances of it being contested is very small, I'll say that.
But I mean, even if you did contest it, you would have to prove.
Yes, you have to prove it.
So, that person was not in a sound mind.
Exactly.
Okay.
Yeah, so if you can't prove that, you're not gonna win. Okay, so there's different types of living trusts, two major types, revocable and irrevocable. A revocable one provides flexibility and control, meaning that the grantor, the person that created the trust, can change the terms and add or remove assets and terminate the trust at any time. Management. The grantor often acts as a trustee managing the assets and managing their own assets during their lifetime. But when you have a trustee, you have to designate a successor trustee. In the event you become incapacitated, or another person that you designate as a trustee doesn't want to do it anymore.
Excuse me, who's normally the trustee? I mean, the person oversees it, is it a relative or?
The trustee, I'm gonna get into, that little later. Okay, so another reason that the revocable trust is good because it avoids probate. And then in the living trust, you can provide for incapacity. In the event the grantor becomes incapacitated, you have to indicate, who's the doctor that they're gonna see to validate this incapacity. And they just can't say that, she's incapacitated. No, prove it. Provide proof, evidence. Now, irrevocable trust is permanent. Once you create an irrevocable trust, it cannot be changed.
Okay.
It cannot be changed. But I recommend that people create a revocable one because you're gonna have situations that may dictate that it needs to be revised in some way.
Right.
You may, for example, say, I want to give my daughter $50,000, but then later on, 6 months later, I want to give her $30,000. And you can make that change because it's a
Okay.
revocable living trust. If it was
Okay.
irrevocable, you wouldn't be able to make that change. So the advantages of a living trust are it provides privacy. It does not have to be recorded, and your assets in the estate plan are not open for public view. It avoids all legal fees and expenses associated with the probate process. It avoids a lot of emotional trauma and aggravation of a complicated probate court procedure. It provides for property management and disbursement during your lifetime and after you die. It protects against a conservatorship procedure, where the court appoints someone to make personal and financial decisions if you become incapacitated. So it protects your assets, and it also provides flexibility. You can prepare a living trust that accommodates all types of situations. Say, for example, you have a special needs area, you can accommodate, put language in a living trust to accommodate that special needs area. And like I said previously, it eliminates delays in settling your estate because it doesn't have to go through the public, so that your beneficiaries will receive their assets back. See? Now, the key duties of a trustee are asset management, beneficiary distributions, and record keeping. So the trustee is tasked with preserving and managing the trust assets, which can include investments, real estate, and other property. So basically, they have to make prudent decisions, investment decisions, and buying or selling assets, for example. They have to distribute the assets pursuant to the specific terms in the living trust. And they have to keep records of financial transactions, income, and distributions. So when you select a trustee, you need to select someone that you know personally, that has good financial management skills, is trustworthy, dependable, and reliable. Okay.
Now, question, in that designation, let's say your daughter doesn't have that mindset, they have the ability to go hire someone, right?
You can,
So even though they don't have it, they can go get someone to act, right? Like they can hire someone to do it.
yeah, they can, but see, that's where I recommend that you name a trustee and a successor trustee.
Okay.
And you can hire a company. There are some trustee
company.
companies, trust companies, then you can hire a cleaner. They can be kind of expensive, because they're gonna want a percentage of your value of your assets. And if your value, your estate is $1 million, they want 1% of that. You see what I'm saying? So shop around.
How about an attorney like yourself, and we become good friends, get to know you, know my kids, I can get you as a trustee, like, I'm gonna charge you too much.
It's gonna be on the spot. No, we can negotiate a fair amount. Yeah.
So you can't get an attorney?
You can't get an attorney.
Well, no, we'll make sure, right?
You can't get an attorney.
You know.
So a trust versus will considerations. So I just talked about the advantages of having a living trust. So, do you own real property? Do you have minor children? I also handed out a questionnaire for everyone to complete. And so, Tara, she's gonna collect the questionnaires after you complete the questionnaire. Now, charitable trust. One method of donating to a charity is through a charitable trust. And there are two major types: charitable remainder trust and charitable lead trust. A charitable remainder trust is where income interest in the property is distributed to you and or your beneficiaries, while the remainder interest goes to the charity at the end of the trust term, basically, and you go. So I have an example here. So if you receive $30,000 annually for your life, then the remaining assets go to the Red Cross, for example, if that's your main charity that you want to receive your assets. Okay. Now, charitable lead trust is where income interest in the property is distributed to the charity first for a fixed number of years, maybe 10 years, 15 years, and then after that term expires, and the remaining amount goes to your heirs. People that you name, for example, $80,000 will go to your charity for 10 years, and then the remaining amount goes to your sister. Now, I mentioned the power of attorney. That's key and critical. That should definitely be part of your estate plan, not just living trust, but a power of attorney as well. And there are two major types: general power of attorney and durable power of attorney. Now, the general power of attorney designates the person to make decisions for you in all matters, and while you're still coherent, mentally and physically. Because if you become incapacitated, mentally incapacitated, then the general power of attorney becomes ineffective. That's where the durable power of attorney comes into play. So you really need to have both a general power of attorney and a durable power of attorney. Now, the durable power of attorney, of course, you designate a person to make decisions for you regarding specific matters such as managing day-to-day finances, paying bills, banking matters, handling assets such as selling a property. And it remains operational even though the person that made it becomes incapacitated.
Question.
Yes.
On the first one, what was the first one again?
General power of attorney.
You said they will make decisions for you while you still think, you know.
Yeah, you still sound mind.
Would you want that though?
Yeah, because say for example, you go out of town and you need someone to sign, documents related to selling the property. You're not gonna be able to do that for some reason. So you designate Joe Blow to do that.
But
So they have a power of attorney.
Okay. And you would only utilize them for certain situations that you weren't able to take yourself, but you wouldn't have to deal with your check account, paying your bills and all that though. Were you capable of doing that yourself?
Yeah, exactly.
But so they would have complete control of all your finances.
No, it's not. It's basically on the stipulation in terms of the power of attorney.
Oh, so you would
So you-
customize that?
Right,
You
exactly.
customize it.
Right.
Yes. 'Cause you said good to have both of them, right?
Excuse me.
Yes.
Can you repeat the question? You know, when you speak this way, it's kind
Oh,
of
okay,
hard for us
yeah.
to listen back
Oh,
in.
okay, sorry.
What was the question, so I
The
can?
question I was asking her, why would you get the first one, the general power of attorney, if you're capable of paying your own bills and doing things on your own, instead of just giving that control to another attorney?
Right.
But she said, I left out of town, for example, and I had some property I wanted to sell, and I wasn't able to be there for the closing or something like that, the power of attorney would give the attorney the capability of doing that for me, or anything else that I wasn't able to do. But I was saying, but she said, you customize it though, because I always want to give attorney control over all my finances, while you still got your mental capacity.
But I'm thinking with, and I'm just playing devil's advocate, I'm just thinking now, we have so much online, .log, you
have other avenues that if I am out of town, I still can could make decisions and sign my own paperwork because everything is electronic.
Take it out,
Well,
Yeah,
you see, it may not
the phone
necessarily, it may be
everywhere.
electronic, but it may not be necessarily safe. See what I'm saying? Because a lot of people are penetrating these, electronic type of platforms. Stealing people's identity, all kinds of things. So think about that. They may say, oh, it's encrypted, but some people may still be able to penetrate that platform.
Like quick claim deeds that
Exactly.
people are doing,
Right.
signing those, quick claim deeds, still property.
Yeah, exactly.
So sometimes
And
you
then-
can't trust anything online.
You can't. Now, advanced healthcare directive is another document that's a key ingredient for your estate plan. Now, with an advanced healthcare directive, you're appointing someone to make healthcare decisions on your behalf. So that's good because it lets them know your medical team what you want done. Whether you want to remain on life support or not even get on it. So it's key and critical to have an advanced healthcare directive.
Now, if you don't have that, because I know a lot of, especially black people, never do this, right? What happens? Is it the hospital? What happens if you don't have that? You know what I mean? Like if you go into a medical situation and they say, "Do you have this?" and the doctor says, "No, you don't." What happens? Do they make the decisions?
Well, it depends.
Okay.
It depends, I'm not really sure. I'm not really sure. Because hospitals, they have different documents and
Okay.
policies and stuff, so that could vary.
Okay.
So I really can't say one way or the other, but it is important to have.
The doctor is supposed to keep you alive by any means necessary, right?
I beg your pardon?
I'm just trying to piggyback on what his, question was. The doctor is supposed to keep you alive, right? So if you don't have, I guess, directed or do not resuscitate or what have you, then isn't it their responsibility to do everything they supposed to keep you alive?
Well, again, you know,
Just to keep you alive, not to.
Yeah, so sometimes it's decision making, like say for example, a doctor asks me like what is a medication or maybe something, whether you have an allergy or not, or you know, maybe some people went or prefer a certain type of treatment, maybe they don't want the surgery. Somebody has to make that decision and that's not up to the hospital to make that
He's a
decision.
family member, like my
Right.
father.
Mhm.
You know,
So it's not always a life or death, it could just be a medication I'm gonna give to them, or a treatment I'm gonna give to them, or a surgery I'm gonna give to them.
He's a family member now.
Yeah.
In our case with my dad and all, he had dementia and he was very sick. And he didn't have a director. And the doctors, we keep it, I'm trying to have it breath, and they would let us go every step of the way, and so we make decisions for him.
There's sometimes people out there, as they age, they may be alone, they might not even
Right,
have
that's a different
family.
case, yeah,
So
that's
that's why
different.
you wanna still have these
That's
directives and
different.
documents on file.
Yeah.
Well, some family members can contest some things, like, siblings don't, I wanna do
Well, you know
this.
what?
I want
Yeah,
that.
but like the gentleman said there, I've seen over the last 3 or 4 years,
Mhm.
people that die, and they got sons and daughters. The hospital ain't gonna do everything to keep you alive. They'll get their family members in and say, you're gonna make a decision or you don't want to pull the plug or let them live. And most times the family gonna pull the plug because they ain't got money for that long term.
It's a financial decision for the hospital, yeah.
I know hospital not gonna keep you for a long time. You time up a bed, and you got no insurance, they get you out of there. Most times they act all the kids, I've seen it, my aunt, when she passed away, she had 5 kids, they call all 5 of them, they make the decision, they pull the plug. I've seen it happen again and again and again.
okay, so again, see, hospitals, they have different policies, so you really can't really say one way or the other. And they will follow their policies. So, again, it's very important to have an advanced healthcare directive as part of your estate plan. So the doctors and your medical team, and also your family members know what you want, what your wishes regarding this type of situation. Now, the HIPAA authorization, a lot of people are not aware of the HIPAA authorization. The HIPAA rules introduce standards covering allowable uses and disclosures of health information, including to whom information can be disclosed and under what circumstances protected health information can be shared. So it really permits the sharing of health information by healthcare providers, health plans, and health care clearinghouses. So an individual gives consent to have their health information used to disclose for the reasons stated on the authorization. For example, if you die as a result of medical malpractice, alright, and your heir, starts a lawsuit, they need to have access to your medical records. But if you don't have the HIPAA authorization, they're not gonna be able to access your medical records and prove medical malpractice and win in court. So it's very important to have this as part of your estate plan as well. So living trust, powers of attorney, general power of attorney, durable power of attorney, advanced healthcare directive, and HIPAA authorization. So I offer a complete package.
Okay.
So you work hard all of your life to build your assets, so make sure they pass on to your family. Make sure they pass on to your family. Get help with your estate plan, give me a call. And like I said, please, I do have this book available today, which goes into much greater detail than I did today on all the topics that I mentioned. And it's only $20. And I also offer consultations, a 30-minute consultation, which is $85, and an hour consultation, which is $185. But if you purchase a book, you get $25 off the consultation. So I have sign-up sheets and everything. So thank you so very much.
Thank you.
Question.
Yes, I was about to ask, are there any more questions?
My question, about the book, how much you say you get over in the book? After half an hour, right? I'm gonna come and see you.
Okay,
I wanna talk about the trust.
okay.
Yeah.
A lot of my clients, consider putting their homes in a trust. Can you go over the steps or what they need to do? I know, like, contact, if you have a mortgage, you gotta contact
Yes,
the mortgage
yeah,
company.
yeah, I can go over that,
Yes.
Okay, yes, thank you, yes.
Mhm.
So if we have real property, and most people do have real property, that's part of the assets. When you place real property in a living trust, I would have to create a new deed to reflect that the living trust is now the owner of that property as opposed to you as an individual. And that deed has to be recorded. But if you still have a mortgage on the property, you need to ask your lender to make sure that you can put the property in a living trust. Get their approval in writing.
So
Okay.
if you still have a mortgage, you have to get an approval from your mortgage company.
Yes, Right.
And
Most of them will, most of them will. I've never encountered a mortgage lending company that says no.
And you also put your automobiles and everything else in there too?
Living trust, yeah. Automobiles, insurance, bank accounts, all kinds.
I have a client doing a record collection right now. He has a record collection worth almost $150,000. He used to be a DJ back in the day. He has signed autographs from almost all the old school artists and every artist you can think of. And he's got the whole thing appraised.
what happens if you put your home in a trust and you decide you wanna sell? Is that possible?
Yes, you can still sell the property.
That's a good question.
The trust is the seller.
Right, the trust is
to
the
sell.
If you have, your house is still you still have a mortgage on your house, and you wanna put your child's name on it, can you put his or her name on it, and then add another one also, in case, say for instance, the mother and son travel, go up there, and both of them pass? Could you have like 3 people's name on it?
You can have how many people.
Oh, you can, on the deed? Oh, okay.
But the key is, you wanna make sure that the people that you put on the deed are financially responsible.
Okay. 'cause
Yeah, the mortgage company's gonna look like that. There's a different process for that in mortgage that we do when they're either after the person passes or if they do it while they're on, where the lender has to look at the credentials or the financial stability or viability of the person that's taking over the mortgage.
Turn around when you do
Mhm.
it. She has a couple of, so, okay, thank you.
Another question for you. If you put your house, let's say you got rental property, 2 or 3 rental properties, and you put them all in a trust, right? You can go with rental properties too?
Yeah.
And then have the assets that come from the revenue, let's say the revenue that come from the rental properties, you can have that distributed to certain people and have the trust set it that way, how much will be paid out to, let's say, your kids,
Yeah.
on a monthly basis, and take care of the taxes on the property and everything.
But see, I recommend if you have rental property, I recommend that you have that property in a limited liability company.
Put it in the LLC.
Put it as a limited liability.
No, buy the property.
As a
In the LLC.
Not established
Mhm.
Yeah.
because it shields you from personal liability.
Mhm.
If someone were to sue, if someone gets hurt on that property, they're gonna sue the LLC, not you personally. So they're not gonna be able to attach all your assets. See what I'm saying? So the LLC is a very protected device.
Could you do that for your own personal property?
Yeah, you could, yeah.
Could.
It depends, you could, possibly, yeah. Well, some people have purchased their property, you can always transfer it to the LLC. Okay.
But I was,
They didn't hear the
Yeah, we
question.
didn't hear the question.
Oh, I'm so sorry.
That's because you were facing that way.
Oh, I'm so sorry, yes.
So to be a homeowner, it's best for you to have it, your home in a trust.
Yes.
Cause if you
Absolutely.
don't, it's gonna go, even if it's in a will, it's going into probate.
Yeah, if it's a will, you're gonna have to go through the probate process.
If you have rental property though, you said to purchase it in an LLC.
Purchase it with the LLC, establish an LLC,
Yeah.
I can do that for you. Because it shields you from personal liability. If someone were to get hurt on that property, they would sue the LLC and not you personally, so they
Right.
wouldn't be able to have access to your personal assets. And there's a tax advantage also to LLC because, from understanding, all the income that the LLC receives is based upon your own personal income tax rate, as opposed to like a corporate tax rate. Most people's personal income tax rate is lower than the corporate tax rate, so it's a tax advantage as well.
On the state side is assets protection. The IRS just looks at an LLC as the sole proprietor.
No, it depends upon how you elect to be taxed.
Well, yeah, if you wanna be taxed as a corporation.
As a corporation or a partnership or.
Yeah, the steps, but normally it's the sole proprietor.
You said some good stuff, I can't hear that, I didn't hear that.
She was saying
The taxes with the LLCs?
Yeah, she was saying that, first she said it, IRS looks as a LLC as a sole proprietorship. But then it's based on the elections you choose as that sole proprietorship. You can do an S corp, you can do a partnership, or you can do a limited partnership, or a C corp. So it's,
For the property?
no, for the
Yeah,
the LLC's tax designation.
Right, okay, well, once you put
She
the
was
property to
saying-
the LLC.
She was asking about her rental properties, and
Right.
Carmen said is put your rental properties in the LLC,
Right.
which will give you assets protection on the states as we want. If you ever get sued, it can't come after your personal assets.
How about the tax, how about the tax side of that though?
Okay, Brazil is a tax accountant.
You gotta pay property tax for the house, right? How they do that to the LLC, the same way.
it's an expense against your LLC. It's just like any other thing you list in a line item. So it's an expense, on your, it comes out as an expense, yes.
It's proper for your tax on the house. But you
Yep.
still-
Yep.
Either way, it's gonna go.
Okay.
She was saying that her house, she's mortgage free.
Oh, okay.
If she put it in a will, it's still going through probate.
Yes, it's still gonna go, you can go on that, get the living trust, I'm telling you.
Yeah,
She put it in little trust, be better, right?
Yes,
Yeah.
absolutely.
Absolutely.
yeah. The, like she already said, the layers, right? Trust is at the bottom. I mean, excuse me.
Trust is at the
Will
top.
is at the bottom. Trust is at the top. That's the reason why people who have a lot of money, you know, typically Europeans, they always do that because it protects you.
Yeah.
Yes,
About how much is it to get a living trust up and running and, putting the assets in?
That's a good question.
Like a range.
That's a good question.
okay, well, I offer two different things, I offer, you can just get the living trust itself,
Mm-hmm.
or you can get the package. The living trust itself is $1,500 plus $40 to draft the deed and record it.
Okay.
And she's the most affordable attorney I know. I work for attorneys that charge up to $17,000. In my office, we used to do at least an average starting at $4,000.
Yeah.
That's just for the living trust itself.
Yeah.
Just for the trust itself,
For the
yes.
package, which is the living trust, the power of attorneys, the health, advanced care directives, and hip authorization, that's $5,000.
Which is still good. I know lawyers that charge $20,000.
Question to that though, as
Yeah.
well, so that's the package for the 5,000, are there any other expenses, outside of you that go along with it, or is that included in the package? So like, I can't even think of one.
If you have to update, make changes, like you said,
Yeah, that's
Is there a fee for like the health authorization with oh, I don't know.
Are you trying to like make it like à la carte, you do like a?
Yeah, not à la carte, cause I know what you you are gonna do, but I'm just wondering, is that the total cost of everything? Cause I know, you know, health directive is.
All inclusive
It's all
for
inclusive.
everything,
Yes,
okay.
all-inclusive.
Another question for you.
Yes.
When you put the trust together like that, and you acquire more assets, you add them to the trust.
That's right.
That's
So
a
that
fee.
means you have to modify the trust.
Mhm.
Not
That's
modify,
a little
that's a
extra.
fee, that's a, yeah, I can't feel that. Yeah, when you do modify the trust, you always add more assets to your trust.
Yeah, you can always change a revocable
Yeah.
trust. The key is to have a revocable one.
Revocable.
It's
Right.
changeable.
Right.
Okay.
Well, it comes right at the time of death, right?
Sorry.
At the time of death, it.
Yeah, at the time that it becomes irrevocable.
Yeah, that's a-
Okay, okay,
Nothing-
can't change it.
nothing can be changed.
That's
So they
right.
can go back and change it, change
Yeah.
it.
Yeah, you're gone. You
Right,
can't make the change.
that makes sense.
What's the best place to, keep your trust? Save the deposit box,
Okay, definitely not a safe deposit box at the bank. no.
Mm.
No.
The best place to keep your documents.
Mhm.
Of course, you want to let your trustee know where these documents are.
Mhm.
Okay. A safe place in your home.
Okay.
Say it could be a small safe deposit box in your home, not in a bank.
Got it.
Yeah, so at the bank, when we have safe deposit boxes, you have to have access to it. And it's a whole process. You can't just let people, it's very strict. In fact, we had to drill some boxes open, like, but it goes through months and months of processes for them to even be able to gain access.
Okay.
Yeah, it's not, yeah.
So you don't wanna have it at the bank house?
No.
You definitely don't wanna have it at the bank house.
You can have your attorney to have one copy, you keep a copy, and then you give a copy to one of your kids.
That's a
To your
good,
trustee.
yeah.
Whoever
To the trustee and to the attorney too.
Yes,
Because
attorney.
you got some trustees and attorneys that are not trustworthy.
Yeah, you're right.
You know,
They have to control them, but that's
hurt you
bad.
bad too.
Well, you know, they also had those fire boxes for your documents.
Yeah, I've seen that.
Yeah, that way, you know.
At the bank?
No, this is
For
the
a
one
home.
for your house.
Yeah.
Yeah, it's just a firebox you put your files
Yeah.
in.
You make sure you put you on somebody got an extra key or a combination, and you got the file body, nobody got a key, or combination.
Okay.
So the thing is trust, I like the living trust.
Yeah.
Like living trust.
So I have sign sheets. Anyone who wants to sign for a consultation, let me get my sign sheet.